Good morning. We're gonna get started. Just to mention that there is simultaneous interpretation English-Spanish. So if you need it, you can request the device in the back in case you need the interpretation services. Well, good morning, everyone. Thank you very much for being here. Thank you for the co-facilitators of this workshop. We're very happy to be here, and we appreciate that in this very early morning, the second day of activities, you made it to the session. So thank you very much. My name is Jaime Chavez Alor. I work at the Vance Center for International Justice, a program of the New York City Bar Association. As part of what we do, we have an institutional integrity program where we include everything related to anti-corruption, transparency, judicial independence, and more. And I'm very happy to be here, particularly because we have a great group of people, experts, who will be talking a little bit about what they're doing, their work, their experience. But the idea is that this session is a workshop, so we want to hear from you. We want to know what you're working on, your perspective. So there's going to be somebody with a microphone that can give it to you so you can participate. So thank you much for being here in this workshop, From Silence to Safety, Strengthening Legal Protection Frameworks to Empower Whistleblowers. We're going to be talking about the challenges, lessons learned, best practices, and innovative solutions. I think we all agree that whistleblowers are key to shed light on power holders' secret wrongdoing. But we know that this is challenging. This is very, very complicated to implement. So we want to understand a little bit more about how the legal frameworks are relevant and key to this endeavor, talk a little bit about the challenges, discuss maybe some good practices, and we want to talk about the practical side of this matter. How do we do this? What do we need to do, the legislative and advocacy actions, and to enhance whistleblower protection and support. So we're going to get started. I don't want to talk too much because we have great experts here. So we are going to start with the legal framework from different regions. I'm going to go in no particular order. But I want to start with my colleague and friend Carlos Guerrero from DLM. I want to ask him about the whistleblower framework in Mexico. It would be very interesting if you can let us know what discussion has there been. I understand there's a difference between a letter versus whistleblower. So if you can tell us a bit about that. And just for you to know, the idea is that the participation will be very short. I'm going to stare at people if they start talking a lot, because we want to hear from you. We want to have your participation. So, Carlos, thank you.
Thank you very much, and thank you everyone for being here so early in the morning. Also, many of you may be jet lagged, so thank you for being here, and also for your interest, on whistleblowing matters. This morning, I want to talk about the transformation of the concept of whistleblowers, the transformation maybe to improve the perception that whistleblowers have all over the world, in my case, in Latin America and the Caribbean. Let me tell you about the experience in my country, Mexico. In 2019, the Mexican federal government decided to implement and introduced the concept of the alerter, the one who alert. And it defined it as the person who communicates prior to the start of the procedure on administrative and civil matters, not criminal matters. And also, the alerter is the one that provides vital information with regards improper or illegal acts by public servants. The alerter is a novel concept internationally. But why do we need these new concepts? We should reflect on these legal frameworks, the legal frameworks that change the perspective on the alerter. Sorry, I don't see everyone. Is this new concept part of the definition to improve the perception of whistleblowers? Is this part of an effort by the governments to improve the participation of the citizens? We should be questioning if this new definition affects the level of the protection available to whistleblowers. Does this create, let's think, any confusion about who is entitled to what kind of protection? In Mexico, for example, it's very interesting because the alerter is only entitled to report some kind of acts of corruption, bribery and embezzlement, not anything else. But at the same time, the alerter is the one that can get protection from the government. The other concept, the reporter, does not have that benefit. So let's reflect on your own countries. Let's reflect what are the legal frameworks that your country have on this end. And let's reflect if we need, at this point, to change the perspective and to change concepts. If we need to be talking about alerters, if we need to be talking about reporters, whistleblowers, in each context you will know, and this is what I want to pick your brain on, what do we do on this end? For Mexico, or any other country, it could be negative, and it is actually, if the concept of whistleblower or whistleblowing is poorly defined. Having then a precise legal definition is critical for the frameworks. Luis Portas will tell us about, in her intervention maybe, about the experience that we had at the conference of state parties at the, for the UN Convention Against Corruption back in December in Atlanta. These were part of the discussions that we were having. How do we translate whistleblowers into Spanish? How do we translate whistleblowers into Danish? The context and the concept itself might have a great impact. An improper translation definitely could lead to barriers in understanding and implementing protection system. I don't know if I have much time, but I can stop here.
Thank you, Carlos. That was very interesting. Thank you for being brief. We appreciate it. So from Mexico, and I have to mention that we've been working together in a project together with Colombia and Argentina. I see Andres is there because in Latin America, many countries are in different stages of their whistleblower laws or efforts. So from Mexico, we're gonna Africa. Liesl Grunwald. I hope I didn't butcher that. Executive Director of the Ethics Institute. Tell us what's happening in Africa, where the efforts are, and I know that we're speaking about 53 countries, and we don't have time for 53 countries, but
don't worry.
an overall would be great. Thank you.
Thank you very much. I'm also going to stand because there's a couple of people that I can't see. So I bring you greetings from my beautiful continent, Africa, where we do things a little bit different to the rest of the world, okay, as you will see. So I'm just going to touch on a few of the 53 countries and then the gaps in terms of these countries as it comes to whistleblowing protection or whistleblower protection. Now, the three goals of whistleblower legislation are, of course, to encourage the reporting of misconduct, to protect the whistleblowers, and thirdly, to require investigations of the cases that have been reported. And this is where many countries in Africa really lacks implementation, also in their laws are very silent about this. So mainly in most of the jurisdictions in Africa, we see that they afford little to no protection to whistleblowers, and therefore that culture of distrust actually continues and is perpetuated, and as well as retaliation. Although some of the laws in Africa are quite robust, it lacks implementation, and a case in point is Namibia. And Namibia has had their whistleblower protection law since 2017, and it was a novel idea, and what they profess in their law is a decentralized approach to the powers and the bodies responsible for whistleblowing, or receiving whistleblowing and investigating it. So we see in most of the other legislation in Africa that there's a centralized authority to take care of whistleblowing reports and ensure that it's investigated. But in Namibia, they decided to spread the responsibilities quite widely. And so whistleblowers can report to any of the authorities that the law has appointed, as well as to civil society organizations, depending on the nature of the disclosure. So I quite like the idea that one can also report to civil society organizations, but maybe that is just I. All right, so on paper, this law really provides good protection of whistleblowers in terms of retaliation. But we see, for example, there is Johannes Stephenson, who is the fishrot whistleblower. And I urge you to read up on fishrot. It's a form of state capture. He has been a whistleblower, or he is a whistleblower, but the law does not afford him any protection. He needs to be, or he is a state witness, yet the law provides him no protection. And in his case, he has suffered severe retaliation to the point that his health has been severely affected, and he is waiting for the law to be implemented, especially the Witness Protection Act, so that he can return to Namibia to testify in this fishrot case. I'm moving to a next country, which is Uganda, and it stands out from the other countries on the continent in the sense that they have quite a robust law. Excuse me, the English is failing me somewhat. And that is because they criminalize the retaliation of whistleblowers. Okay? Criminalize it, so that is really good. And they also have an authorized officer, and if that authorized officer does not commit or act upon the receipt of a whistleblowing report, that authorized officer also commits an offense in the law and can get imprisonment or a fine. Kenya has had a very long journey to develop their whistleblowing retaliation policy or protection policies, and that it actually goes back to 2003, which is actually long before it became fashionable, if I can put it that way, to have protection laws in place. And in 2003, they ratified the UNCAC, and also in 2007, as well as signed up to the AU Convention on Preventing and Combating Corruption. And both of these instruments require that there must be legal mechanisms to protect whistleblowers, but Kenya still to this day lacks an overarching whistleblower protection law. Okay? And yeah, we are now in 2024. Okay, so provisions to safeguard persons are scattered in the Constitution and in many laws. So instead of having an overarching law in Kenya, they have different laws like the anti-bribery law, they have an ethics law that addresses whistleblowing protection to some extent. The problem, okay, now in 2015, civil society stepped in. So I'm really thankful for civil society, also in our country, in my country. And this task force that was responsible for the review of the legal, policy and institutional framework in fighting corruption, then recommended the enactment of a whistleblower bill. Now, thankfully, Kenya started to draft this bill in 2017, and it evolved in the Protected Disclosures Bill. So there, in 2019, so there's progress. It's not perfect yet, but there's progress. And then, of course, all the other laws had to be amended, the anti-bribery, anti-money laundering, etc. The whistleblower protection bill is aimed at, and there are three areas here, which the one I find interesting. Of course, it is aimed at strengthening the protection of whistleblowers, as we would expect. But then the second one is to promote a culture of whistleblowing in the country. Okay? Promote a culture of whistleblowing. And then, of course, provide the safeguards against victimization, retaliation, and the like.
Sorry.
Yes,
I don't want to interrupt you.
Ach, nee, man. I mean, no.
I love
right.
that people are standing up, but I can't stare at you.
Okay, all right.
If you stand up.
But I will talk about South Africa. Just one thing that I wanted to say is that when I talked about Namibia, although Namibia has had that law for so long, it has not been implemented. And then the last thing in terms of legislation in Africa is that there are challenges, like everywhere. So the main challenge is a lack of political will, cultural nuances when it comes to who is a whistleblower and what is a whistleblower, and then, of course, a lack of resources. Thank you, Jamie. I'm now
Thank you.
finished.
We're going to come back to the European Union. So I want to ask Marie Terracol, how's my French, to tell us about what's happening here with the directive. Thank you very much. And Marie is a whistleblower lead at Transparency International.
Thank you, Remy. So talking about what's happening in the European Union, so like a lot of you might know, there's been this EU directive that was adopted in 2019. And well, that was really a game changer when it comes to whistleblower protection in Europe, because it sets minimum standards on whistleblower protection that all the member states of the European Union have to meet. So like TI, we were a really long time advocate for such a directive, and we were very involved in the entire process. And we have to say we're quite happy with the result. Of course, there are weaknesses and room for improvement. Well, there is always room for improvement, but it really provides a strong foundation for whistleblower protection in Europe. So since the adoption of this directive, all of the member states have adopted or amended their law on whistleblower protection. Poland is the last one about to do it right now. And so 27 EU countries, and then also the 10 candidate countries to the European Union also have to do that. So quite a wide reach with this directive. And it has many strengths. So I mentioned weaknesses earlier, but I'm still going to talk a bit about strengths because there are many. And one of them is that it allows whistleblowers to report internally to their organization, but they can also go directly to the authorities. And we've seen that actually in many circumstances that's the best option, or the whistleblower might be more comfortable with it. And it also allows public disclosures in many circumstances. So that's one of the strengths. There is also an obligation for a large number of organizations to set up internal whistleblowing system, and they have to, and the authority as well, they have to follow up on the reports they receive. So they have an obligation to do so, which actually is something we don't always see in laws, like they're often silent on this, and they have to keep the whistleblower informed about the results and the outcome and what they're doing about the reports and what's happening with it. So also a good point, the protection of the whistleblower identity is quite strong. It really sets minimum limited exceptions, and it provides some safeguards as well. And it protects against retaliation, so both at the workplace but also against legal proceedings, or against criminal suits and civil suits, and we've seen actually that happening in several countries before that. So that's quite an improvement. And there is also no good faith requirement, so which is something we've seen in many countries and has been very challenging. And so it's now if a whistleblower reports information that they believe to be true and they report it, well, they're eligible for protection. They don't have to prove that they had pure motives when they reported, which often is kind of used against them. To try to, launch some investigation to try to find some dirt, to show that they don't have any, pure, they don't have pure motive in doing what they're doing, even though it's actually not very relevant. And lastly, the employer, those who have retaliate, are the one who have to prove that they didn't retaliate, so that they didn't take detrimental measure because the person blew the whistle, and not the other way around, which we've seen in many jurisdictions was a real problem, because, it's difficult for a whistleblower that goes against their organization to prove that the measure that were taken against them was actually taken for that. There are also issues, as I said. The first one is that, well, none of the member states of the European Union are actually fully complying with the EU standards. So, they could have done better on that. And Transparency International is definitely working on it. So we're following that very closely and trying to push for changes there. And but a big challenge is the material scope of the directive, because, it's really a crucial element of any whistleblower protection law, because it's basically what type of wrongdoing someone can report, and that falls under the directive. So it's the information that the whistleblower can report, and for which they will benefit from protection, but also which will trigger a response from the organization, from the authority. And so even if you have a law that does everything else, has every other element right and follows best practice, if your material scope is very, very, narrow and fragmented, then the law will be completely ineffective. So that's basically a really big issue. And unfortunately, the EU directive has a narrow and fragmented scope for various reasons. And most of the member states have not chosen to have a wider scope, although they actually could do that, and they were encouraged to do that. And that will create a lot of issues in the following years, next few years, when they try to implement. Because, in some countries, it really takes a lawyer to determine which case fall under protection, the protection of the national law. So it's very intimidating and dissuasive for whistleblowers, instead of really making it easy for them to speak up, which should be, the aim of any whistleblower protection law. So I'm not going to go further. I know we're limited on time. Just to say, so that was a bit of an overview. We're going to see the implementation in next year, because, well, from past experience, this is actually where most of the challenges start, and so a lot to do.
We're going to talk a little bit more about that. Thank you, Mai. So we're going to go to the Maldives. So I want to ask Sayed Ralwina, I hope I didn't butcher that, from Transparency International Maldives. So where are you? What's happening? If you can tell us a little bit.
Good morning, everyone. We had our Whistleblower Protection Act enacted in 2019, and it was a bill drafted by Transparency Maldives. We had a whistleblower who was prosecuted in 2016. He was a bank manager who leaked statements to the public, which actually helped investigations of our largest corruption case to date. So he was jailed for more than 4 months, and he was under house arrest for a long time. So our Advocacy and Legal Advice Center actually supported him with on his legal case, as well as in calling to drop the case. And we also worked with a lot of international agencies as well as international community to pressure the government to drop the case. He was, unfortunately, he was convicted, but he was released immediately because he has already served his sentence. We were able to lower his sentence. What we realized at the time was, although there were laws that should have protected him, he was charged by the same laws. The Banking Act, he was charged under the Banking Act because he was releasing confidential client information. He was also charged, I think there was penal codes that was also referred. So what we realized was, although there were these fragmented protections within the legal system, it didn't provide when it came to especially attempts to challenge those who are in power, it really didn't provide any protection. And what we saw was this was a case which later on we realized that had so many public officials or existing in power at the time were implicated at different instances in this case. So we actually started working on the law after this case, and we were able to present it to the parliament in 2018. So that was also a time when the government changed, so we were able to push it through. The law actually also, we referred to the to TI's principles for whistleblower legislation, and we also worked very closely with Transparency International in drafting the bill. So our bill also adopts a broader definition of wrongdoing. It also provides a broader definition of whistleblowers, including individuals in both the public institutions as well as private businesses. It also offered anonymity and confidentiality, and allows for disclosures to be made with reasonable belief, and the burden of proof rests on the employer, and also provides protection for mistaken whistleblowers. So the Act was quite comprehensive in terms of the protections that it offered, but we have seen since then, it was enacted in 2019, we see that there's very, very little political will to actually support institutions in implementing these or complying with the Whistleblower Protection Act. So even after the Act was enacted, we have been working very closely with oversight institutions like the Anti-Corruption Commission as well as the Human Rights Commission, where the Whistleblower Protection Unit is now established. What we found was even for the first year, they didn't have any staff in the Whistleblower Protection Unit, permanent staff there, so we didn't have anyone to work with, but we helped them with producing advocacy materials as well as training, and also in drafting and revising their regulations. But still, I think there's a lot of work that we need to do in terms of implementation, especially in strengthening these accountability institutions. When we look at, we've been doing some monitoring of how organizations work through our RTI efforts. And what we see is there are very few institutions which provides the mechanisms like whistleblower protection mechanisms on their website. So people are still not aware that these protections exist. And what we often see is them resorting to other means of leaking information through the social media, through anonymous accounts. And we've seen efforts by the government, again, to try to find out who leaked the information. So in terms of enforcement, political will is the biggest issue, and when we speak to these the oversight institutions, they are also not able to enforce when they try to tell them you shouldn't be, provide protection, they're not heard, so they don't have the legal authority to actually go through with their recommendations. So this is a huge step up for us, but even though the law is there, we don't see people coming forward as they should. But we have also, when we look at data, in the last year, there were about 21 cases that were referred to the Whistleblower Protection Unit, but these are the people who shouldn't technically be able to get the protection from their institutions through existing mechanisms. So there's still a lot of work to be done, and it has to start from political will and getting enough support. Just as an example, when we look at the budget for the Whistleblower Protection Unit last year, it was $3,000 for programs. Just imagine what you can do with it. So we've been working very closely in bringing them and supporting them in rolling out and trying to create more advocacy around it, whistleblower protection. So as a civil society, we've been trying to advocate for it, but we need more commitment from the government actually to make it possible.
Well, thank you very much for that. I think that a lot of us can relate to those challenges, so thank you. So, Luis, the idea is that all of these frameworks from the different regions are following the international standards. We have Article 33 of the UNCAC, and from your work at UNODC, what can you tell us about these international standards and how they're evolving?
Thank you very much, Jamie, and good morning, everybody. Thank you for being here so early and with so many people. So yes, indeed, I'm working for UNODC, and we are the guardian of the United Nations Convention Against Corruption. And in that convention, you have the Article 33. Article 33 asks countries, states parties, to consider providing or consider adopting measures to provide protection against unjustified treatment against people, persons that are reporting offense of the convention. First of all, I want to state here that Article 33 looks very broad, but there is already a distinction made with witness, because witnesses, experts, and victims are covered under Article 32. So the convention already had the objective to separate reporting persons to witness and victims. But yes, the convention was adopted in 2003, and we were not that far in the concept of whistleblowing. A lot of things have been done by the international community, the organizations dedicated to the question of whistleblowers. So we should not single out the convention, the Article 33, from the rest of the global standards of the world. Article 33 should now be read in the light of what has happened. We had several evolutions of the standards. Just very briefly going through them, in 2013, for example, we had the first model law on whistleblowing from the Organization of American States. In 2019, we had a big jump because we had the G20 high-level principles on whistleblowers, as well as the EU directive. And this is where we really see the term whistleblowers appearing on the international scene and progressively evolving and like being better defined and a bit separate from the rest of the word, let's say, reporting persons. We also had another jump in 2021, and we speak about it with the ISO 37002, which speaks also about whistleblowing and the updating of the OECD recommendations. So we do want to state here, Article 33 is still the international basis for the single reason that the UNCAC is the only one instrument that is almost universally ratified and that is legally binding. But again, we are not reading this Article 33 separately. And actually, the Conference of States Parties, so the states parties to the convention, did recognize that in December. In last December, Carlos mentioned it, we had a very important resolution adopted by the Conference of States Party, which is about the protection of reporting persons. So yes, there is no whistleblower in the title, and that was a big debate that we had because many countries did not recognize that term. But we have the term whistleblowers inside the resolution. And the resolution consecrates the term whistleblower and say that this is a category of reporting persons that are made aware of wrongdoing in the context of their professional activity or work-related environment. And the resolutions now provides the mandate, request us, UNODC, to continue providing technical assistance to countries for them to better define, to strengthen their whistleblower reporting and protection mechanisms. And we have, by the resolution, this mandate to really continue advocating on better distinguishing the term whistleblowers from the term of other categories of reporting person, especially a big confusion that is being made by countries is confusing whistleblowers with witnesses. So this is the biggest part of our work, and since the adoption of the resolution, we actually received, let's say, an increasing and ever-specific number of technical assistance requests. So we also have to always be more experts, to develop our expertise, because countries do evolve, frameworks do improve, and we also have to improve our expertise to keep providing technical assistance in line with what the countries needs. And just the two things is for instance, more you speak about whistleblowers and more countries try to develop this concept, and more you have people who think they are whistleblowers, but they are not, or vice versa, which increase the vulnerability. So it's very, very important to clarify the concept. And one emerging concept also that we have more and more in our technical assistance provisions is a gender impact of whistleblower protection and how to address that and how to make whistleblower reporting and protection mechanism more gender sensitive. But I'm already teasing for another workshop that we have tomorrow morning. So you are welcome. Thank you very much.
Thank you very much. So when you're talking about technical assistance, the other side is that not necessarily all laws and provisions have been completely effective, and governments still need to do a lot of efforts. So I want to ask Samantha Feinstein from the Government Accountability Project. So where are we in terms of these frameworks being effective? That's fine. I can stare at you if you're standing up, but you'll know.
Well, I have a timer.
Okay.
So I will hold myself accountable and whistleblower myself. I guess it's my phone will do it. Okay, I have this, but do you want to switch? Okay. Thanks. Okay. All right. So I have a question for the audience. Let's just do a show of hands. How many of you come from a country with a whistleblower law? That's a pretty good result. I see several people with their hands down as well. How many of you come from a country with a dedicated law on the protection of human rights defenders? Interesting, and that comports with what I'm seeing as well. And show of hands, how many of you have come from a country with a law that protects witnesses? About equal or almost maybe a little bit more than whistleblower protection. What about informants? Protection laws. A lot less. That's interesting. And what about protection of journalists? Okay. More than informants, but absolutely less than everyone else. So I'm going to talk a little bit about the revolution of whistleblower laws around the world and some trends that I've found through some of my research. So there's been a global revolution in whistleblowing, and we've seen this even before the pandemic, but I think especially in this circumstance where our literal lives and interconnectedness depended on information and reporting and transparency and accountability. And that's where we really saw the suppression of free speech happening across the board everywhere. And that's why we need whistleblower protection laws. They're our eyes and our ears. And the United States, as the first country with a comprehensive legal framework on whistleblower protection, became sort of a testing ground for whistleblower laws, because we have some 60 federal whistleblower laws. They're all a little different. We've tested different systems. They're all ineffective in their own special ways, but it's actually from failures that we learn and where we get the best practices. And the best practices that Louise mentioned were developed in cooperation with civil society groups from around the world who are learning from successes and failures and what works. And that's why some of the newer laws and the EU directive even itself, as Marie mentioned, is now the sort of gold standard for whistleblower practices. And that really catalyzed sort of next wave of countries adopting whistleblower laws. So the EU region, of course, accounting for most of the new whistleblower laws, but there's also, to mention, many bills and amendments being worked on, and that's worth mentioning as well. So about 170 countries have some form of a whistleblower law, whether it be comprehensive or something narrow or weak or sectoral that just focuses on, let's say, anti-corruption or environmental whistleblowers, but doesn't cover a broader range of reporting illegality and misconduct. Now, I found that now all EU member states have a whistleblower law, which is a huge victory, and all NATO countries do as well. For the UNCAC member states, I estimate that about 33% have what I would describe as a comprehensive whistleblower law. But you can add, another 20% of sectoral whistleblower laws for UNCAC member states. So it's clear there needs to be more work on legislative frameworks. The Government Accountability Project and the International Bar Association teamed up on a study looking at litigation and case decisions in whistleblower cases, and also comparing their legislation to the 20 best practices of Government Accountability Project, International Bar Association, OECD, UNODC, et cetera, which are largely consistent. And the best whistleblower frameworks comply with 16 out of 20 best practices. And I think the EU directive would probably go even further, but it doesn't have jurisdiction over national security whistleblowers, and that's one weakness, which I'll get into in a second. But by and large, most fell quite below that. Canada, for instance, with 1 out of 20, although their parliament is I don't see. But there's in Canada a whistleblower law that we've been working on that would amend their whistleblower law for a long time. So there's some motivation ever since the EU directive passed for countries to match the standards of the EU. Part of this is because there are international companies that are looking to comply with the EU directive because they may have offices in the EU as well as other countries, and it's to have something more cohesive and that complies makes sense. And so there are some kind of efforts to harmonize the best practices. And one of the really amazing things that the EU directive does is require companies with 50 more employees to have an internal reporting channel. And so I wanted to share with you some other trends that we took away from the International Bar Association study. One is that there is a lack of implementation of whistleblower laws and a really small number of cases. So the UK and the US were sort of the most litigious and had the largest case sample. And we found that about between like 10 and 12% of whistleblowers won their cases. So that means about 90% or so are losing. So in reality, it's really important to close the loopholes and work on whistleblowing systems and other things for them to actually work in practice. So there's more than legislation that needs to be done. We also found that the intelligence community had second-class rights. We saw a trend in more whistleblowers being protected from criminal and civil retaliatory lawsuits against whistleblowers, also known as SLAPP suits. But we also found that 19 countries in our study did not protect against SLAPP suits at all. Another trend or observation that I wanted to make was that whistleblowers, in some instances, were being given a motives test, and now the trend more and more is to make motives irrelevant. So now, since I'm at time, I will just briefly conclude some takeaways that I'd like to leave you with. is we really need to do more on the technical assistance side. We need legislative support and teaming up with civil society, governments, and different stakeholders to make that happen and close all the loopholes. We need to focus on systems that support whistleblowers, like strengthening the rule of law, having independent investigative agencies that are properly funded, staffed, and have enforcement authority. Otherwise, you're just leading the lambs to the lion's den. And there's more that the private sector can do where the government is failing to sort of pick up on strong legal frameworks. I'll just maybe leave it there, but also wanted to plug that at 3:30 this workshop will continue and pick up on some of the things we will not have time to discuss today.
Thank you. Yes, at 3 o'clock we have another workshop, room 1, the lived experience of whistleblowers and partnerships to advance whistleblowers' rights and protections. So we'll continue the conversation there. And we're coming to the part when you're gonna tell us about your countries and best experiences. But first, I wanna ask Wim van der Kerkhoff. There are other standards, and Luis already mentioned the ISO 37002. But if you can tell us a little bit more about that and how it's being implemented and what's its advantage, that would be, we would appreciate it.
Thank you, and good morning, everyone. So the ISO 37002 is the whistleblowing standard. All ISO standards come with a number. So the 37001 is the anti-bribery standard, and so the 37002 is the whistleblowing one. The title is actually Whistleblowing Management Systems Guidelines. So I think the best way to think about this ISO standard is to see it as a consensus on what best practice looks like in handling whistleblowing reports. So it's, if you're gonna have a whistleblowing channel, what's a really good way to run it, to operate it? What does this back office look like? What sort of planning do you need to put in place? What sort of procedures? Who needs to do what, etc. In terms of consensus, I think it's a quite strong consensus. There were about 160 experts from 35 different countries, multi-stakeholders approach that developed the standard. And some people who are on the panel were part of those working groups. Marie Terrecourt and Elise Grunewald were part of the working group. So I think it's a quite strong consensus. But the consensus on what does it actually look like to run a good whistleblowing channel and a good handling process, I think this is where the value of the ISO standard lies, because it complements legislation. It complements whistleblowing laws. To take the example of what we have in Europe now, the EU directive. So the EU directive says every legal entity that has 50 workers or more needs to have an internal whistleblowing channel and system. But it actually, there's very few legal requirements in that directive for the internal systems. So the legislation doesn't give an organization the handles to actually do it. The EU directive says, well, you need to have a whistleblowing channel, you need to have an initial acknowledgement within 7 days, and then within 3 months some feedback, and you need to maintain confidentiality. And that's really important in the EU directive, that emphasis on confidentiality, and that's an important one. But I think the ISO standard allows an organization to say, okay, how are we actually going to do this? I'm a researcher, I'm an academic, I do a lot of research on whistleblowing, and I focus on internal whistleblowing systems and how these channels actually work. So I talk a lot to people in organizations who try to run these systems. And from my experience, there's a tiny minority of organizations that do a really impressive job, and they wow, you know, the way they do it. It's great organizations, great culture, but it's a tiny minority. There's also an equally tiny minority on the other tail, where you talk to them and you think, like, oh my God, what an awful organization. You know, it's a bunch of crooks who got together, is run. But I think the big majority in the middle is, from my experience, is they would actually they see reason in, if someone raises a concern internally, they want to handle it well. So there's goodwill, but on goodwill alone, you're not going to be successful at handling a whistleblowing report. So you see, they have goodwill, but they still mess it up. They mess it up, and if organizations make mistakes, they're not very good at admitting mistakes. So then you see organizations try to cover up, and it totally escalates. And I think it's that middle block that the ISO standard can actually help. And there's a lot of ground to win there in terms of empowering whistleblowers. It's by helping those who want to do a good job actually doing a good job. So I think in terms of the general principles, I think if you look at TI's principles, Ethics Institute principles, ICC guidelines, and the ISO standard, they will say the same thing. Okay, so I don't think there's a problem there as to what guidelines you look at, but I think the sort of added value of the ISO standard is that it's written as a management system standard. So it really says who needs to do what, how, and when. Leadership. How does leadership needs to show? How do they need to show commitment? It's not just by signing the policy. Yes, a policy, what does it need to say? But then it's really about how do you do triage? How do you do investigation? What do you do when you close an investigation? What does the follow-up need to be? Throughout this whole process, think of the whistleblower. Who's taking care of the whistleblower? Ideally, that's not the same person as the person who carries out the investigation. What sort of protection measures do you actually already have ready for when you need them? You can just push a couple of buttons and the protection mechanism starts. Does the protection start at triage stage? It's all those different things, and I think the ISO standard is very useful for that. So I think if you use this standard, any organization who uses it, they will be better at doing triage, they'll be better at giving feedback, they'll be better at data management. And so data management means keeping confidentiality, but also there's a heck of a lot of personal data in a file when it goes to investigation. So when you close, do you delete everything? What do you keep? All those kinds of things. I think, especially within the EU, that's going to be quite important when this is starting to become enforced. And I think the ISO standard can help a lot there. That's a lot of things. One thing I want to pitch, it's very brief, is we've developed a tool, a free online tool. It's anonymous as well. We don't collect IP addresses, but it's an online tool that's called SUSE. It stands for Speak Up Self-Assessment. There's a little flyers like that at the end of the room. There's currently a beta version up. We'll actually launch it. It will really go live next month, and we'll start in 7 languages. And any organization can actually use this self-assessment tool. You answer a bunch of questions, and at the end you get a score on different dimensions of the ISO standard. It also tells you how well you align with the EU directive, and it gives you a sense of your speak-up culture in your organization. So please pick up those flyers, have a look. You might not be the target audience, but you might have good ideas on how we can help, or how you can help to promote this tool, or just general ways of getting this. It's a free online tool to the benefit of everyone. Thank you.
Thank you. Thank you. Last but definitely not least, we have Stephen Kohn from the National Whistleblower Center. And I want to ask you, Steve, because a lot of cases require a transnational approach and there is transnational laws. So how do we flip the risk that whistleblowers have in these kind of transnational situations?
Thank you. And that's what we'll get into. First, I'm honored to be here before such a group of dedicated human rights activists. It's a true honor. We are at a crossroads in the fight against corruption. For the first time, effective transnational whistleblower laws exist permitting NGOs, the news media, and whistleblowers to file confidential reports holding the most corrupt entities accountable. These transnational laws cover 4 deadly acts of corruption: bribery of government officials, money laundering, bank secrecy, and corruption in the international commodities markets. They provide extraordinary protections. Not only are identities shielded, but they offer unprecedented monetary compensation to whistleblowers whose allegations are verified. Nearly 15 years of empirical evidence has demonstrated that the most powerful, corrupt entities in the world can be held accountable based on whistleblower disclosures. We just have one flyer handed out that just covers some of them, and you can see what's going on today. Consequently, prior opposition and skepticism regarding the payment of awards to whistleblowers is finally coming to an end. In 2014, the United Kingdom, their regulators issued a report condemning reward laws. Well, times have changed. Now the director of the UK's Serious Fraud Office has completely reversed that position based on empirical evidence. I'm going to read you his words because this shift in position sends a message. This is what he said in February 2024. I think we should pay whistleblowers. If you look at the example of the United States, their system allows for that. 86% of the $2.2 billion recovered was based on whistleblower information. He then pointed out that 700 UK whistleblowers had come to the United States to use that transnational system. And if 700 whistleblowers from the UK can come to the United States, whistleblowers from every country, and we've documented 135 countries using these systems. Moreover, given the success of these laws, they are actually improving. In late December 2022, the United States Congress passed the Money Laundering Whistleblower Protection Enhancement Act. This law is the most powerful transnational anti-corruption law in history. Although my organization, the Whistleblower Center, took the lead to get this law passed, it was fully endorsed by every major whistleblower organization in the United States, including the US chapter of Transparency International and the Government Accountability Project. We explained to Congress how whistleblowers had been key in identifying $240 billion in illicit assets flowing from Russia and former Soviet republics into the West. The result? Unanimous support for this enhanced whistleblower law. Every Democrat, every Republican, 100% support. And that law is now in place. The question now is, where do we go from here? And this brings me to the OECD audit of the US anti-bribery program, which contains one of these model highly effective laws. What did they conclude? I'm going to quote from it now. We recommend that the United States enhance guidance about the various protections. That recommendation has not yet been implemented. They specifically said that education was needed, quote, to help potential whistleblowers. What they are saying is there's an incredible set of laws in place. They work. They hold companies accountable. They hold the corrupt accountable. But there's widespread ignorance throughout on how these laws work. And they pointed out that many, many whistleblowers are not getting the compensation and support they are entitled to. I can tell you right now that I know of billions of dollars where the whistleblower came forward, reported the corrupt entity, did everything right, but by ignorance into how these laws work, they can't get justice. As an anti-corruption community, we cannot sit on the sidelines while whistleblowers, due to ignorance, are denied their rights, their compensation, and the ability to use these laws to effectively fight corruption. We have to change. This is one of the reasons why the National Whistleblower Center is doing everything in its power, and we're a small organization, to try to bring education about these laws to light. We are hosting a seminar tomorrow, there's information about it, in which we will be able to go into detail. Because just touching on these large issues does not really help that much. People need to know how these laws work when you go back to your country so you can implement. And we're willing to help with that in any way we can. So I just want to conclude by just one thing. We have a number of flyers. This one, I think, says it all right here. It's the actual decision of the United States Securities and Exchange Commission awarding $104 million to 7 international whistleblowers from 3 different countries who reported bribery. This is an unbelievable breakthrough. But the widespread, as the OECD pointed out, most people do not know how these laws work, let alone that they exist. So I want to thank Transparency and the panel and all of you for caring and permitting me to be here. Thank you.
Thank you very much, Stephen. And I know that you're anxious because we've come to this part where you are gonna be doing the talking. So who wants to share? We're looking for best practices, interesting developments in your countries. Yes, please. I know there's somebody who's gonna be passing the microphone. There was a lady over here, and then we have other hands. Thank you. Well, you get the microphone over here, standing up. Thank you.
Thank you so much to the panel, and particularly to my countryman, sister, and Dr. Groenewald, Liesel. I'm rising to say that there is a need for us as African countries to have an AU minute. We've noted from the experiences of other regions the importance of regional pressures. Now, TI in Europe led the process of getting a regional unit. Given Africa's particularly vulnerable industries, I'll just mention 2. We have a predominance of armed conflicts in our continent, and the defense industry does unspeakable crimes on our continent, and arms deals are notoriously corrupt. Given the fact that we have rich resources, even though we suffer from Dutch disease, and the extractives industries is one of the corruption industries that are most vulnerable, we definitely need interregional and continental collaboration. So if you see a note from me, my name is Thandeka Mbeki. I'm from NACAC, the council appointed by the South African president, particularly our African colleagues. Please do not be surprised. It's about an AU minute.
We had another hand here, here in the back. If you can stand up. It would be courteous, but not mandatory to introduce yourself, please.
I don't mind. My name is Monica Mwansa. I'm from Zambia's Anti-Corruption Commission. Good to see you, Luis. Thank you all for the wonderful and insightful presentations. Mine is to add to the sentiments by the lady next to Marie on her right. Sorry, I've forgotten your name. I liked it when she mentioned that the protection of identity of whistleblowers is quite cardinal. We do have laws, many of us in the room, like we were asked by our panelists there, many of us raised up our hands, but the implementation of those laws is very difficult. So with regard to Zambia, what we're doing is to ensure that we protect the identity of the whistleblower before we think of actually implementing the laws that provide for the protection of whistleblowers, because it's difficult to actually provide for that protection. So interestingly, what we recently did is to introduce an anonymous online whistleblower system where whistleblowers are encouraged, where people are encouraged to report corruption to the commission. So far, we've gained a lot of confidence in the system that when we review the kinds of reports we received, we even have reports touching on some of the officers of the commission, which shows the confidence we're already providing to the public with regard to protection of the whistleblowers. We are also working on reviewing our laws, and we will be adding to the overwhelming request to you, Luis, to ask for technical support as we review our laws, and we hope we can have Steve to work with us. I thought I'd share on the online whistleblower system that we are working with to protect the identity of whistleblowers. Thank you.
Thank you very much. You're going to get a lot of requests for technical assistance.
I'm coming to Zambia in August. We are going to discuss that.
Great. Here, please, in the front.
Thanks. I'm Pablo from Mexico. And the question, well, first of all, as Samantha said already, I guess we've been labeling between whistleblowers or human rights defenders without acknowledging that human rights defenders are usually whistleblowing within their activities. There's a Netflix documentary called The Guardian of the Monarchs. You can watch it. And it's the risk that human rights defenders usually face. And I think that the risk that a whistleblower faces, it's depending on the risk of the corruption case you're whistleblowing. It's not the same whistleblowing corruption within a public office than corruption related to organized crime. So my question would be, in talking about strengthening legal protection frameworks, I think that we should not leave beside the conversation the authorities in charge of enforcing them. And the importance on understanding in the implementation of the convention articles how we need to either understand or identify if we need to have like independent authorities that are the ones who grant the protection measures, or if it's the same authorities that grant them and investigate, because like in this documentary you will see how it's even the prosecutors that give tip to the people who's gonna retaliate or put you at risk. So how do we grant this protection and like this standard for whistleblowers if it's the same authorities you're whistleblowing to that put you at risk? So I've kind of like put this question in Atlanta to Ms. Louise, so it's kind of going further on that. Thank you.
Thank you, Pablo. So I'm assuming that question was directed to Luis because you were looking at her. We're gonna leave a couple of minutes at the end to answer like the different questions, but I want to continue hearing from the audience on best practices, examples.
Thank you very much. My name is Shakil Ahmed. I'm the Member of Parliament from Kenya. I'm also the chairman of the African Parliamentarians Against Corruption. It's a caucus that was built 20 years ago together with TI. They're our partners. What we provide is a platform for civil society to work with the legislature. Unfortunately, the whistleblowing element we have some laws that we are passing, but they are stymied, if you know what I would mean. They are being frustrated. I know the transnational law, you have the Transnational Whistleblowers Act or law. How can we take advantage of that and get linked into that so that we may be able to provide in the law that we have already the law's been, the motion has been there for something like 8 years. We're in the process of finalizing it. How could we link into it so that we can give the whistleblowers international protection? Thank you.
Thank you. There was another person, I think, here. Over here. Yeah, thank you. Over there, yeah. You can stand up.
Hello, my name is Ilan. I'm from TI Panama, and Panama at this moment doesn't have a whistleblower protection law. The most recent bill was introduced a few years ago. It went through the first reading, but it stopped there. Now there were elections a month ago, and we actually had a pledge where many candidates for the parliament signed on to a series of anti-corruption laws that they would push if they came in. One of them was whistleblower protection, and the number really of parliamentarians who are committed to this has increased exponentially. I mean, they don't have the majority, but they have a strong group. We actually did a number of roundtables with candidates and civil society, and we discussed the bill that was introduced in 2020 that included rewards to whistleblowers, but some of the attorneys who came from the Attorney General's office, the prosecutors, they argued that the reward might complicate their ability to have a conviction, because they said that the defense might argue that a whistleblower was only putting a complaint to get money and not out of good faith. And so people might not be convicted of corruption and other crimes. So I don't know what the response to that might be.
Thank you. And I'm going to give a few minutes for people here to answer some of those questions. But does anyone has an experience here that could share that talks about those incentives and the money component of that? There was here, yes, please.
Hello, my name is Jorge Martinez Rivera from Whistleblower Chile. In Chile, we have adopted the American system, the Dodd-Frank system for corporate whistleblowers. This year, after 3 years that the law was enacted, the first 3 rewards were paid. There are some issues with the program that is being ruled right now regarding these rewards. In first, there is a lot of secrecy of the agency in charge of making all the procedures, deciding who is a whistleblower, who deserves a reward, how much is going to be the reward. There's total secrecy. Nobody knows who deserves a reward and why they are paying these rewards. So it seems to me that when we do the legal transplant of these institutions, we have to be aware of what are the conditions of different countries, because we can maybe be building, I think, that some traps, because in Chile we have rewards, but we don't have protection for whistleblowers. So what happens if the whistleblowers go to the system to get a reward, fails, the employer knows, but we don't have any rights for whistleblowers in the labor code. So we have to be very careful, and that's something I would like to raise here, that we are talking a lot about how many countries are creating whistleblower laws, but whistleblower is, in many countries, is not part of our legal culture. Whistleblower is something very radical. I defended whistleblower in my country, and the judges don't understand the public interest involved. The employment tribunals are not, the procedures are not able to translate what is a public interest case in a system that was created to defend employees for unfair dismissals. So we have to be aware of that, how to hardwire whistleblowing, the best practices in those countries that we don't have a legal culture on whistleblowing. So that's my experience in.
No, thank you. Thank you very much for sharing. That's very interesting. There are a couple of hands here. So the lady, yeah, next. Thank you.
I'll pass it directly to Jim afterwards. My name's Anna Myers. I'm the executive director of the Whistleblowing International Network. And I wanted to sort of leave a question with Liesl, but also make a comment on the issue is very different in different countries, and the role of civil society who've been working on the ground and actually understand how power works, have supported whistleblowers, are absolutely key to any of these legal protection frameworks working in practice, but also those organizations have been involved in every single one of these international frameworks, starting with the Council of Europe recommendation, the EU directive, bits of the OAS, the Organization of American States, work on whistleblowing, although not yet fully developed, as well as the EU directive and the UNCAC resolution. And part of the reason is because these organizations work with whistleblowers, and that's the other end of the important cases and the evidence base that works for politicians, especially if they're from within their own countries. So I would like to just also ask Liesl to comment, because there was an organization called the Open Democracy Advice Center in South Africa that ended and was one of the founding members of WIN, but it no longer exists, and there's a newer organization called the Whistleblowers House, and it'd be really good to sort of see what you're doing and just to raise that, that there are more NGOs that are taking this on with public interest lawyers and whistleblowers also being part of the mix. So just wanted to leave that, and I'll hand it to Jim.
Yeah. Hi, everyone. My name is Jim Wasserstrom. I'm a whistleblower, and I'm also an anti-corruption troubleshooter professionally. I just wanted to not let us get down the awards rabbit hole. I think that's great, Stephen. Great work. However, it's not the main focus. The main focus is actually legal protection for whistleblowers. And what's been shocking to me, and I have usually a group of whistleblowers that I'm advising at any given time from a variety of organizations from different countries. And what was always shocking to me was in 2019, when the EU directive was first announced, and with the deadline of December 17, 2021, that here we are in 2024, and the law, and it hasn't been properly transposed. It's been transposed really abysmally, with all kinds of holes, and I think Marie, you mentioned it in very nice, very diplomatic language, but it's really not been a success at all. So I think the point that Samantha made, which is plugging the loopholes, I mean, I participated in a session in the country where I live, which is Greece, with a group of more than 100 parliamentarians and others, where I promoted the idea of whistleblower protection, and they nodded their heads, and then they spent the next hour trying to figure out all the ways around the EU directive, which is exactly what has happened in the majority of EU countries. And those are rich countries. Those are OECD. Those are G7, G20. And those are countries with the resources to do the right thing, let alone the countries which are struggling this process where whistleblowers have almost no protection in reality. And let's not forget that the whistleblower concept also includes penalties and punishments for those who propagate retaliation themselves. And there has been one successful prosecution globally for that purpose. One. Not in Europe, not in North America, not in Africa or in Latin America. It was in Asia. So it is an enormously overlooked piece of whistleblower protection, is to send a message to those who perpetrate retaliation that there are punishments for them too.
Thank you. There's a participation here in the front. Here, Andres. Yeah, and that will be the last one because we'll have a few minutes. You'll have like 30 seconds.
Yeah, thank you. My name is Andres Hernandez from TI Colombia. I just wanted to say thanks to many people in the panel, in the room, who have helped us promoting the whistleblowing protection legislation in Colombia. We actually managed last week to have the first out of 4 discussions in Congress. So it's moving on, and it's been really great, the power of actually convening all these experts in the room, and furthermore to support national level efforts. I wanted to come back to the issue of rewards. I fully agree with what was said about rewards. We definitely put it away from the discussion because it would distract the attention on the actual protection that we needed for, or that we want to advocate for in terms of whistleblowing. And perhaps my last point would be around, while there are many countries that still need to make progress around legislation, continue using all the very good knowledge that you all have about thinking of the effectiveness of the systems that we are pushing for, as well as something that I'm always reminded of, that is that it's great to have whistleblower protection, but we also need that the judiciary system or the entities in charge of actually investigating make results. So somehow we need to put this in the context and monitor that situation as well, because it's about results. It's not only about, well, of course, very important whistleblower protection, but which are the actual results, or the final results that we want to achieve.
Right. Thank you very much. And we'll continue this conversation at the workshop at 3 o'clock. But I just want to give literally 30 seconds to each person. If you want to say something, so yeah.
Vladimir, can you raise your hand? Folks from Mexico, I'm just going to +1 what you said, because just those were all facts. Mexico's context is pretty unique. However, I think the best success story that exists is in Serbia. So I want to connect you with Vladimir to talk a little bit about how they went from the beginning of actually quite a mess to a success story with the whistleblowing system that is actually protecting whistleblowers from retaliation. And so we can learn from each other's examples, even though each country has its own totally unique context. And I learned that when I went to Mexico, and we had very interesting conversations. Okay, moving on. Panama, I will connect with you on Panama after this, because TI, Panama, and GAP teamed up on an assessment of this bill that you were talking about. And the problem with this one is it was like citizens turning in citizens. It was not really a proper whistleblower bill. It was kind of an attempt to do the rewards, but not well. So in that case, we were actually advocating to veto the bill. But I'm encouraged that there's interest, and I had submitted some proposals to TI Panama to State Department to work on this issue in the past, if this is ripe for action. I really think it's important to actually, for donors who are in the room, to actually invest in whistleblower protection and supporting and advising these systems. The UNCAC resolution even calls for UNODC support for this.
Time.
Okay, done.
Luis.
I'm not sure to do it in 30 seconds. I just want to mainly answer on the question about central authority. Just to say that, yes, it's true that some of the countries, some of the laws have established what we call a whistleblower protection agency, which has a certain authority to provide protection, but also authority over the workplaces to reinstate whistleblowers or to take any administrative sanctions against an employer who would have retaliated against a whistleblower. However, I just want to mention this comes with a cost. This comes with like a special system, and this is not something that can be done, everywhere. It's not like a one-fits-all situation. So you have to look at your national situation. What is important is to somehow have an agency or a body that is coordinating, making sure that the law is implemented in an harmonious way, but it's not always possible regarding the national situations to be given to this authority, sort of like, court order power, if I may say so. So just to say that, and for any technical assistance requests, we can discuss after the workshop. I'm very happy to discuss on one-on-one. Thank you.
Wim, do you want to say something?
Yes, very brief. I want to pick up on this, the remark there on who grants protection, who investigates. Is that the same agency or not? This is also actually part in the ISO standard. It says ideally, there's a lot of benefits if you separate that. Of course, at country level, but even at the level of an organization, there's many benefits to that. I want to link that with the comment on the crap transposition of the EU directive, and that's my word, but that I think that was sort of the okay, fine. And I think this is one area where we'll need to see how is this actually going to be working. So the experience of, for example, in France, the Défenseur des Droits, initially was taking a position on this is a whistleblower. We see early on judges weren't following the position of the défenseur. At this moment, it seems that they are starting to follow it. If you look at the House of the Whistleblower in the Netherlands, they also want to have that mandate, but they really need to put up a fight to get that mandate. So I think it's just starting. Yeah.
There's 3 words, Carlos. 3.
Just want to point out the amazing opportunity that we have as a community here to use these best practices that we've been talking about on vulnerable communities. Back in December, with the Cyrus Vance Center for International Justice, we released a report on the impact that corruption has on migrants and asylum seekers, and it's just concerning. So, thank you.
Thank you. No, thank you. Liesl.
Thank you.
4 words.
Fast forward. All right, just one thing, 2 things. One is that the context of countries are different or continents. In South Africa, many whistleblowers are assassinated. So it is something, the protection that's currently in the different laws is not providing the protection that our whistleblowers need. And Anna referred to the Whistleblower House. 3 years ago, a couple of us established this civil society organization because we realized that there isn't a holistic protection of whistleblowers, and what the Whistleblower House does, we are reliant on funders, which finally, after a year, we got. We facilitate access for whistleblowers to free legal advice or representation, free psychological assistance, which laws don't address, safety and security, moving them around in the country, moving them out of the country, and financial assistance, a small stipend, which they can use to pay school fees, buy airtime, etc. After they have lost their jobs. I'm a director there. Ben, raise your hand. He's my chief executive officer. And lastly, so the one to speak to, in 3 years' time, we are now looking at 290, after 290 whistleblowers.
Thank you.
Okay, thanks.
Marie?
Thank you. Maybe just to answer to Jim on that, the EU directive itself is quite good. a lot of member states have not done a very good job, like actually a pretty bad job at implementing it. Greece is actually one of the worst examples, so I get you there. But there are some really good examples, like France, for example, is actually a good example. So yeah, and just to add that on the reward issue, it's actually very controversial, like in many, and it really depends on the national context, I think, and like what's really important is like it really shouldn't replace protection and compensation, because reward shouldn't be confused with compensation, which is, you know, reparation and remedies for the loss, the actual loss for the whistleblower, and I think that's the key element here.
Thank you. Sayed?
I think what I just want to add is, as civil society is working in this space, it's also important that we are also protected, because I think we are at the forefront of a lot of these SLAPE cases and other threats from, especially from the government. So if we are not protected, it's difficult for us to then protect others. So that's also something that donors should also consider. We do find a lot of efforts going to government institutions, and so there needs to be more coordination and collaboration with the donor community as well as international agencies. So I just wanted to highlight, especially when we are trying to reach the vulnerable groups like migrant workers. In Transparency Maldives, our legal advice center is mostly used by migrant workers, and a lot of these cases can very easily become whistleblowing cases. But it's very difficult for us to pursue it further than just trying to get their salaries back. So, yeah.
Thank you. Stephen?
Sure. So, first, the comments from Chile and the struggles you're having. So, you need our laws, the transnational laws have due process, mandatory standards, and judicial review. Without advanced protections built into the law, it just won't work. Second, the comment about we need to push for protection laws as opposed to award laws. The two work hand in hand. In point of fact, without an advanced democratic infrastructure, a reward law cannot work. Therefore, the transnational nature of the US laws permitting whistleblowers from around the world to benefit from the due process and advanced standards becomes a critical element that should be fully integrated. And as the person from Kenya, the parliamentarian, pointed out, we can work together to understand how these laws can be effectuated worldwide. Thank you.
Thank you so much. Thank you for staying with us even a few minutes late. It has been very interesting, an honor for me to moderate this panel. The only thing I want to say is if you need pro bono legal support for your substantive anti-corruption work, please come talk to me. Thank you so much. Thank you. Thank you all. Thank you.